So question I always get now is, now that Trump is going to be elected or has been elected, will take office in January, how will that affect real estate syndicators? And I've come up with 5, and I wanted to go through them real quick. So the first thing, accredited investor, right? I mean, we've been talking about the accredited investor rules for a long, long time. In fact, if you guys remember, and I've talked about this before, the SEC already passed an accredited investor rule that extended the definition of an accredited investor to those who took an exam, right? It's already there. We don't have to come up with a new rule or have to come up with anything special. The rule is already there and passed, which would allow people to get certified as an accredited investor by passing an exam. The stalling that happened, or the reason it hasn't moved forward, is that the SEC then had to designate the institutions that would give the certifications, give the course, give the exam, give the, the testing, all that stuff. They had to certify certain institution, whether that's, I'm thinking folks like, it could be FINRA, it could be, Kaplan, or some of these companies that provide training for people studying for exams. That just never happened because the rule passed in October of 2020. And of course, we had the election in November and then the new administration in January. So that literally was tabled and didn't go anywhere, to the point where we also talked about this, that Congress got involved and they started passing or putting through their own legislation, basically mimicking the rule from the SEC, allowing accredited investors to become accredited by taking an exam. And there was literally, I think, 10 different variations of this legislation. So there's actually about 10 laws that were passed, but they were passed by the House of Representatives. So the one I talked about a lot always was the Equal Opportunity for All Investors Act of 2023. And that passed 383 to 13. I mean, not even close. Blew by the House of Representatives, but then got stuck in the Senate. It's been sitting in the Senate since June of last year. So over a year now that it's been sitting there. So there's a couple of ways you could go here. You could say, hey, now that the, Congress is basically also turned, that you could finish that process of the legislative process. But to me, the easiest thing that's going to happen is you're going to see a new SEC commissioner come in, obviously, for sure. The way it works, by the way, I'll just do a little parenthetic here. The way it works is there's 5 SEC commissioners, and they're all appointed by the president, but they have to be somewhat balanced. So there's always 3 of one party and 2 of the other. Currently, the commissioner is Gary Gensler, who's obviously a Democratic nominee. So what's going to happen is he's going to get replaced. The question is going to be, is he going to remain on the committee, just not as a chair, and somebody that's already there is going to be promoted to chair? Or most likely what happened last time, and almost always happens, is that Gary Gensler will resign. And so President Trump will then elect a new person, most likely going to be the chair. But it will now turn again to be sort of a 3-2 majority, more pro-business, pro-real estate. So I think all of the things that were on the table prior to the last election will be brought back in. And I think accredited investor might be the easiest, quickest, fastest one to get through because, again, the rule already passed. We don't even have to do anything else other than designate the institutions that can give the accredited investor thing. Number 2 is the finder rule. I was talking a lot about the finder rule, but this was a rule essentially that allows people to go raise money for others and get paid a commission, a co-GP interest. I mean, this was huge, right? And it made sense because there's a gap. So I always preach, because it is what it is. I don't blame the messenger. But right now, the rule is that you have to have a broker dealer involved in order for somebody else to raise money for you, unless you find an exemption, which is where, not to get in the weeds, but there's that issue where exemption. But the problem with broker dealer is that it's a lot of work for them. They don't want to get out of bed unless they're raising 25, 50, 100. They want to raise big bucks. They've got to do all this due diligence, all this work. They don't want to do it for $1 million or $2 million. Now, there are smaller ones that over the last few years have popped up and are doing smaller deals. I have had some clients that are using brokers that are raising 2 or 3 million and getting a hybrid commission, maybe a 3 or 4% commission, and also a cut of the GP. But there's a gap in the market, and I think this is what this rule was meant to be. Now, that one was not final. The status of that rule, and I'll go through just as a reminder of what it was so you guys can get super excited like I was. The status of that is there was a proposed rule. So there's like a 37 or 40-page proposed rule, which I will probably link. I'll link it in the community, Real Estate Syndicator live community on Facebook. And then when this gets dropped on the YouTube channel, I'll also drop it in the comments. But it's about a 40-page rule, and I'll go through it in a second. But that's a proposed rule. So that never actually got voted on, again, because of the change of administration. It just wasn't a priority for the chair. And I think what'll probably happen on that one, I would suspect that they put that out again for another comment period. So generally these rules get proposed. There's a 30 or 60-day comment period where all the parties, the attorneys, the regulators, the investors, the sponsors, everybody can kind of comment on it. And so there's a comment period, and then usually they review that and they make some tweaks based on the feedback. And then usually, I don't know, 2 or 3 quarters after the proposed rule, they come up with a final. We never got to the final stage, so I wouldn't be surprised if they just reissue comments. Hey, here's the proposed rule again. They may tweak it a little bit, ask for comments, but that process will move forward. And again, usually within 6 to 9 months of the proposed rule, that will come out. And what was beautiful for this one, it had its limitations, right? It wasn't you can just raise money for others carte blanche. So some of the limitations were, there was no general solicitation for this, right? So let's say I'm the finder and you guys all here on the show today are the syndicators, obviously. So if I had a list of people already that I knew, that I was in my database, that I have a relationship with, and I wanted to make an introduction or refer them over to you, then I would now be able to get a commission. Literally, just, hey, I'll send you this person. They're looking for a deal, but you've got to pay me 8%, 6%, 5%, 20% of the GP, whatever you want to do, you can get transaction-based compensation, which is usually the hallmark of, or it is the hallmark of broker-dealer activity. But what they didn't want me to do is go use all of my amazing marketing skills and go grab a bunch of people so then I can then give them to you, right? So that's not what they didn't want to do. But honestly, it does help folks like there's a lot of professionals like CPAs, registered investment advisors, lawyers who would love to refer their clients to sponsors. And now they're going to be able to actually get compensated for doing that. Now, the proposed rule was limited to accredited investors only. So it could only refer you accredited investors and get compensated for accredited. So that's one limitation. It had to be a written arrangement between the finder and the sponsor. So there had to be something in writing, and there had to be a disclosure to the investor that, hey, I was going to be getting a commission. Whoever's getting the commission was going to get a commission. That only makes sense to me because it does affect potentially, if somebody's making an introduction and you know that they're getting compensated for that introduction, it can definitely affect their perception of the deal. And then they just couldn't get too involved in the deal. So there was no investment advice, no handling of the funds, no negotiating terms, no due diligence. So literally I can show them the PPM and the business plan. I can show them the deal, but I couldn't advise them to it. But it really, really opened up this idea of getting compensated to raise money. As you guys know, this is one of the big things on my pet peeve list of folks raising capital. So I think that comes back. Again, I think they'll just do a comment period. So I think that's the second one. So accredited investors, number 1. Number 2 would be this finder rule. Number 3, I think not necessarily maybe an SEC issue, or definitely not an SEC, but I think bonus depreciation is a given. It's almost a lock, I think. Bonus depreciation, as you guys know, has not been going away. It's been going lower and lower every year. And now you've been having to take the rest of the depreciation over the entire, 27 and a half or 30, whatever the years are. But remember, bonus depreciation passed the House of Representatives earlier this year. Again, overwhelming 357 to 70. It wasn't even close, right? And then for some reason, it got to the Senate and it got knocked down 48 to 44. So the Senate now is flipped. Sounds like the House is still up for grabs. There's a lot of alleged shenanigans going on in the House. So we don't know what the House is going to end up with. But I think bonus depreciation, not only is it a lock, in my opinion, these are obviously pure opinions, but also I think retroactive. I've talked to a lot of CPAs. They've always thought it's retroactive. And so if that does happen retroactively, that means that, in 2025, it was scheduled to go down to 40%. Then if they do that retroactive for, the rule that passed is going to be retroactive, I think, for 3 years. That means you could start taking you basically can go back and amend your tax returns and take 100% bonus depreciation going back however many years. I think the legislation that passed was going back, I want to say 3 years. But so that's exciting. Not necessarily a securities issue, but certainly a real estate syndicator thing that I think everybody's probably super excited about that prospect, because that's real dollars in your pockets. The other one that I think is on the chopping block, I think, and I haven't heard anybody talk about it, but I would not be surprised if the Corporate Transparency Act goes by the wayside. The Corporate Transparency Act, for those, I won't get into the details, but it's essentially a requirement for all of you guys that have entities, right? LLCs and corporations, and obviously all real estate investors and syndicators have LLCs. There's this requirement to provide all this personal private information to the government, the Treasury Department, specifically FinCEN, Financial Crimes Enforcement Network, personal information, date of birth, driver's license, copy of driver's license, information about you, information about your company, if you own more than 25% or control the entity, like a lot of this stuff, right? And there was actually a legal challenge already. We talked about that as well. We've talked about the Alabama challenge that actually was successful. And so there is a case where the Alabama federal court, district court, or circuit court found it unconstitutional. It only applied to the plaintiffs, so it doesn't affect you and me. That's in process of being appealed. But again, it's very simple for it's FinCEN, it's a government agency. They don't need any permission from anyone. They could easily stay that and say, hey, look, let's wait till the law goes through the court system. And if it continues to get appeal and continues to lose, then it'll go by the wayside. I can only imagine how many LLCs President-elect Trump has, right? I mean, just imagine, he probably has hundreds, if not thousands of LLCs in the Trump organization. So somebody over there is stuck doing all of this. I'm sure he's well aware of the pain and the encroachment and the cost and all that fun stuff. So that would not be a surprise for me if the Corporate Transparency Act either got repealed, or maybe I think the easy political escape is like, hey, look, we already have a court that said it's unconstitutional. Let's stay. Let's not continue to enforce it until it makes its way through the court systems. That's one way I think there's a good chance that might go by the wayside. I'd be curious to see what other people think. And then the last one I have, and I actually have a bonus one for you, but the last one is, there's the regulated crowdfunding, which is an exemption that we don't usually use too much, but it's a fairly new one. During President Trump's term, he raised the limits of how much you can raise under this regulated crowdfunding exemption from $1 million to $5 million. At $1 million, it didn't make any sense for anybody to use it. At $5 million, it started to make sense to use it a little bit, but that could, I don't know if increasing that number anymore would help, but I think increasing the amount of money investors could invest, because right now there's a very tight limitation on that exemption. It allows non-accredited investors to essentially put in either 5% of their net worth or income or $2,200. It's a very, very small number. And even accredited can only put up 10% of their net worth or income, whatever's less. So that could be tweaked a little bit. Maybe that number goes up a little bit. So now it makes more sense because non-accrediteds might be able to invest, a more significant amount, 50 grand. Because think about it. I mean, a non-accredited investor that makes $200,000 a year or something, or $150,000 a year, 5% of that is like $7,000. So I think the regulated crowdfunding is something to look out for. And then the bonus one that I was thinking through as well is, there's a little known, not a little known exemption, but it's the other Reg D exemption, right? There's 3 Reg D exemptions. We always talk about 506B and 506C, but there is another exemption, which is Rule 504. They've already increased that limit as well. It used to be a $5 million exemption. It went up to 10. 504 is a really fascinating exemption. It's really great for us. And there's only one reason nobody uses it, but it actually allows you to take, there's no limitation on how many non-accredited investors you can take. So you can take an unlimited amount of non-accredited investors, and even better, for you guys anyway, legally, you're not even required to give a PPM for those. It's almost like the same as a 506, or it's the same as when you give a deal to accredited. You don't have to give them disclosure. You just got to make sure your disclosures are complete and don't omit facts. That doesn't mean it's not best practice to give a PPM, but it does eliminate the legal requirement for that. And so sometimes if you have a really small offering and maybe it's a $600,000 deal, a $500,000 deal, that could make it more accessible. The problem with the 504 is it does not preempt the states. And so that's the reason nobody uses it, because even if you comply, which you easily can comply with Rule 504, you still have to go back and look at the state securities laws where all your investors are located and make sure that you're hiring an attorney who's familiar with the state laws and making sure your deal, fits into whatever exemption each state has. So that's the main reason. That's preemption. I always talk about why 506B and 506C are so popular. It's because they preempt state law, and 504 does not. And so, it's rarely used, but that's another potential thing. I think overall, the theme of this, though, is that just like back in 2016, the Trump administration was very pro-business, pro-real estate, and the Democratic Party was more pro-consumer protection and all that stuff. And whether it's right or wrong, that's not what we're here to do. But in general, they're going to look for ways to expand capital formation, I think, especially if we have some sort of a recession and money starts, which in the real estate world's already tightened up a little bit. I think you're going to see a lot more pro-business, less consumer protection, and more, hey, how do we expand capital formation? Which, by the way, is something that the SEC staff has been fascinating to watch. The SEC staff, they put out especially the small business division or subcommittee of the SEC has always been putting out, encouraging the expansion of things like, let's expand the accredited investor definition. Let's expand the access to investments. And it's more of the other side that's been really trying to limit that. So if you'd like to join us live on these episodes and have a chance to get your specific question answered, you can simply go to realestatesyndicatorlive.com and register to be live on the show. Hope to see you then.